Okay, so we're going to briefly read this one, but this is mostly going to be about the theft of funds, the breach of contract, and so on and so forth, about the appropriation of my funds. So we will kind of ignore the other part. We will kind of maybe briefly read over it, but we won't go into great detail about that particular part of the assault made by the city council worker until a later date, which is going to be like another video specifically on that point by itself. Of course, informed consent. Any company setting up a direct debit is required to clear consent from you before initializing payment. If they fail to do so, this direct debit could be considered unauthorized. Unfortunately, at the time, they did have actual consent because originally it was set up to pay for a council tax that I had at that particular time. But once that debt was paid for, it should have actually stopped. Now, I've already stated myself as well, I should have stopped the direct debit payments myself, but once I informed the council about this direct debit unintended, they should have issued the refund, which they actually did within the phone call when I was talking to some advisor. They stated I would get a refund within 7 to 10 working days. And I waited that 7 to 10 working days, I think it was, and then I contacted them again, and then they refused refund at that particular point in time. So it is difficult to actually prove, let's say, a verbal contract, because you actually have to have the recording of such a thing. Thankfully, I have that email stating I can cancel the funds or whatever from with my bank with that 2 years payment, so I can get my money back. Yet the city council are still arguing that that's not the case. Anyway, what do you do if you experience an unintended direct debit? Contact your bank immediately. If you notice an unintended direct debit, contact your bank immediately to report the issue under the direct debit guarantee. They are obliged to investigate and refund any unauthorized payments promptly. Unfortunately, my bank has not done so, so Barclays, I hate you Barclays. Dispute the payment. The direct debit was taken for a service you did not authorize. You can put in a dispute charge. The company involved should provide evidence of your consent, which Aberdeen City Council have not done. Now, there may have been consent to pay the original amount, but there have not been consent to pay the extra amount for another debt through that direct debit payment for that particular charge, such as signed agreements or documentation, which the City Council has not offered at all. If they cannot provide this, the payment will be considered unauthorized. Oh yeah, and that's the other thing as well. You can't actually dispute the payment for the City Council as well on your card, because I tried doing it and it wouldn't actually allow me to do it. Originally, when I talked to my bank, I actually had to phone them up about the particular issue because I couldn't actually dispute it on the application, you know, for the online application or for the phone. Cancel the direct debit. You have the right to cancel the direct debit anytime. Notify your bank in writing, and they must stop the payments. You can also inform the company involved and stop payments, but your bank cancellation takes priority, which I did at the time. I contacted the city council to stop the payment. I never told my bank to stop the direct debit payments at that particular time because I was a bit concerned, because I wasn't 100% sure exactly what the payments were for. As I stated before, when your payments towards like Aberdeen City Council or whatever, it doesn't say like heating charge, it doesn't say this, and I was under the assumption it was for my heating charge. But I wasn't 100% sure, so I didn't want to cancel it until I got verification. After I spoke to Aberdeen City Council, they basically said, yes, you'll get your refund within a week to 10 days, but then also they said they would stop the direct debit payments. So I did not feel the need to contact my bank at that point because I spoke to customer service essentially. They said I would get a refund, they said they would stop the direct debit payment, and then lo and behold, they did not return the money. They did not fulfill their part of the obligation, and they never stopped the direct payments. So I had to contact my bank. When I contacted my bank to stop the direct payments, then they actually stopped the direct payments. But the city council again essentially are not returning the funds, and they continue to double down to basically state they are not returning the funds, even though they have gave me a verbal contract to state I'm entitled to my money, and also a written contract as well stating I'm also entitled to my money. Review your contract. If you're unsure why the direct debit was set up, check recent contracts, agreements or terms you may have agreed to with a company. Sometimes companies may automatically renew subscriptions or memberships without clear consent. I'm looking at you, Amazon, because they have done this several times. For example, I set up a Prime membership for basically Prime so I can get my deliveries quicker, and I cancelled the Prime, yet they automatically set it up with another bank card I had on my account. There was another occasion as well with Amazon where I never cancelled my subscription at the time as well, but I actually cancelled the card, but then they just looked on my account for another card and automatically set it up with the subscription with that other card. So it is important to be aware of your rights under consumer protection laws, file a complaint. Well, I have filed my complaint and got nowhere. I've spoken to Aberdeen City Council, and technically it is breach of contract, and that is more of a civil issue. But the other issues we're going to come into is the fact that they've committed fraud because they've indicated to local councillors, MSPs and MPs that they never offered any such refund, which at this point that then becomes fraud. They have also then tried to hide the funds, which is then in a form of, it's like an online money laundering type of term. I can't remember the name of it, but essentially it's just money laundering with microtransactions or something. Because what they've done is they've tried to pay Scot & Co the funds from that overpayment of 2 years. They paid Scot & Co and then they refunded the money back to themselves because Scot & Co was already paid for, because I had already paid off all the debt. Each time they made the payment to Scot & Co and refunded the money back to themselves, they just redid the exact same payment over and over again until there was only about £10 left on the account. So I went from about 200 and something pounds on the account to £10. So at this point it is technically a criminal offence because it is technically fraud, it is money laundering, and then obviously the civil part would be the breach of contract, but the other parts are technically criminal, and especially when you're lying to elected officials. Now, of course, with the next part, I'm just going to ignore that section 6, which is basically protecting yourself from unintended direct debits, which is basically pay attention to your payments. I should have done the same. I easily admit this, that was my screw up, but like I say earlier, it does not give the right legally for the City Council to use those funds for 2 years to pay for something else. We can also technically ignore the section 7 as well, because we kind of already went over that, which is basically file a complaint and so on and so forth. We have informed the appropriate authorities, which was the people that actually took the money in the first place. I have also contacted Scot & Co about the same issue. I spoke to Scottish Advice Line for the same issue as well, and also SPSO, and what we've already discussed as well, essentially still being left with no legal recourse because the stage 1 complaint was never taken to stage 2 for such a long time. Now page 3. In the UK, unintended direct debits, whether unauthorised or incorrect, are protected under the direct debit guarantee, which ensures you can cancel direct debits. Get refunds and avoid financial loss. If experience such an issue, act quickly by contacting your bank, disputing the charge and seeking a refund if necessary. If the situation is not resolved, you can escalate the issue to the Financial Ombudsman. You are a former tenant of said address, Aberdeen. Tenancy at address ended on the 13th of March 2022. At that point, the tenancy ended and the outstanding balance remained for rent £741.20. You repaid the outstanding balance via fortnightly payments of £10 and monthly repayments of £20. I gotta ask though, why are you still taking payments if I already had paid the debt? Because that wording, I know I'm dyslexic, but you repaid. Well, if I can emphasise that enough. You actually have an email which we'll be bringing up later where it actually says I have no monies due. These payments were made by you to the former rent account via standing order that you arranged by your bank. Continue to make standing order to the rent account after the balance had been cleared. So they agree and make the statement that I've actually cleared the outstanding balance, yet they're still taking money to pay for something else. Agreed to pay them for that one account. I paid that account entirely, yet they're still going to use the money I unintended to give them for the last 2 years to pay for something else that did not exist because they refunded the money back to themselves through Scot & Co. You made contact with our customer service response team on the 17th of June 2024 to query the payments leaving your bank account for your old tenancy. Our rent accounts team emailed you back on the 19th of June 2024 where they advised you that your former rent account was credited by £217. They advised in this email that you should contact your bank to cancel the standing order. Essentially, when I was on the phone though, the time when I contacted the bank again to say where was my money, they implied that if I would essentially rescind the money, that I would be going against a court order. So by doing that particular thing, it essentially made me query if I can cancel the standing order. And this in itself is an admission that I am due that money back. It's, as far as I remember, one of the emails to the local councillors, when they did a consent form, that they stated they offered no such refund. What is it? Did you offer a refund or offer the ability for me to get my money back or not? Because on one hand you say yes, and then on the other hand you say no. which essentially leaves me in limbo. It's like, legally, they say I'm entitled to that money, I can cancel that standing order, but on the other hand, they say I'll be breaching a court order, and that a request for a refund for this amount would be forwarded to the team responsible for approving refund. This is a kind of like a contradiction in itself, and sets a huge amount of confusion, because like I say already, they've offered a refund as such because they tell me to cancel my standing order, yet in the next sentence they say they haven't technically approved it because they still need to send it to a team to approve. Yet on another email, it also stipulates that I'm to cancel that standing order with the direct view that they will check to see if I have any debt or whatever, but it doesn't stipulate a necessity for me to pay that debt with this particular type of funds. And the reason why it states that essentially is because I have no obligation to pay it with that particular type of funds, because that was not the agreement. The email also stated the checks would be made to ensure that there were no other debts owed to Aberdeen City Council before approving a refund. I swear I just went over that, but it was just a simple case again. Why tell me to cancel my standing order for that payments for the last 2 years if you haven't approved it yet? If they haven't approved it, and showed they haven't approved it, but they tell me to cancel the standing order, legally what am I supposed to do? Because if it's a breach of a court order, but they tell me to cancel my standing order, so they literally give me permission, once again another sentence, to refund or cancel my standing order to get my money back, and then they use a backhanded way to basically say no, you can't do either. And like I said before as well, they basically stated that I'm allowed to cancel my standing order, and it does not state that I have an obligation to pay another council tax debt or another bill or whatever with this particular type of funds, because I have not made that agreement to do so. They may have implied that they want me to pay for that type of debt or that particular type of bill, but I have not agreed consent to pay that bill or that debt with this particular type of funds. But like I said before, they also refunded the money back to themselves from Scot because the debt they implied I owed, I had already paid for. Aberdeen City Council's corporate debt policy states that there were credit balance is held checks with a made for the outstanding debts due to cancel prior a refund being made. Where the checks identifying outstanding debts, the credit will be used to offset these. Regardless of the policy and regardless of any intentions or whatever, they have made a statement that I'm entitled to the money because I can cancel the standing order to that money. On 26th of June 2024, you spoke to a member of staff within a corporate debt team who advised you that you would not be refunded the £217. Now, so I've already had written contract to essentially say I'm entitled to the money. I've had a verbal contract to basically state I'm entitled to the money. They have also stated here I'm allowed to cancel my standing order, yet they turn around and then say I'm not entitled to that money. As there remained an outstanding arrears balance for council tax that was held with the sheriff officer for collection, it is understood you were dissatisfied. Oh God Almighty! Dissatisfied. Oh, for crying out loud! Dissatisfied. Where to God? Okay, to wrap it up, I was unhappy with the decision and brought the issue up to local elected members. You can clearly see my confusion. They offer a refund so I can cancel my standing order on a phone, which is a verbal contract. Then they give me a written contract that basically stipulates that they will check if I have debt, but offer no obligation for me to pay said. And then they try and pay Scot & Co with that said funds and then refund the money back to themselves because that debt's already been paid for. Responses were sent to the elected members advising them the decision to transfer the credit balance to reduce your outstanding council tax arrears were correct and no refund would be made to you. Now, they also stated on that letter as well that they offered no such refund, or they essentially offered no such means of me cancelling my standing order such to get my money back. What should have happened? Aberdeen City Council's corporate debt policy states that the council will adopt a corporate approach to refunding credits, and the checks are made to identify any or other debts to the council before authorising the refund. This is essentially, regardless of their policy, this is a breach of contract. I couldn't give a damn what policy they basically stipulate that, they have. I had an agreement to pay them a certain amount, I paid them that certain amount. They accepted to take a certain amount of money, and they took that certain amount of money. Once it over-exceeded that certain amount of funds, regardless of their policy, it is not law. I have made a contract with them and they're in breach of that contract by using that funds for something else. They have taken that money without consent. In the case of your checks that we carried out identified that you had an outstanding balance for council tax, you were correctly advised on the 26th of June. I'll have to see page 3 for that. But before we actually cover the page 3, we're actually going to go through that letter quickly, where it basically shows that for the Scot & Co payments as such, for them refunding the money back to themselves, and also the part where they send a letter to the local councillor where it basically stipulates they offered no such refund, and where they basically said that they essentially offered no way for me, or should I say, basically, I'm not entitled to the fund.